Peace to the family. Peace to the family. This is part 2. Friend Habitant just gonna get right into it. You know what I'm saying? Finish up this part 2. Okay. We left off in 1:15-4. Okay. In regards to basically in regards to our magistrates, i.e. judges, attorneys of record. Basically, our magistrates, our judges, attorneys. Are they attorneys? Yes, they are. So we're going to finish up on this, family. Okay? All right. Okay. Let me read this right here. Okay? On a general application subject to paragraph B and C whenever R 1:15 imposes limitations of practice of law by an attorney. Such limitations shall also extend to the attorney's partners. Check it out. I'm gonna show you where this is so double speech. It's double speech and it's double talk. And anybody can go do their own research and you can see clearly where it's, as I've been saying in the part 1, where it's ambiguity. They're doing double speech. This says right here, subject to paragraph B and C where R 115 imposes limitations on the practices of law by an attorney, such limitations shall extend. So I should extend to the attorneys, partners, employers, employees, office associates, shareholders in a professional corporation, or members in a limited liability entity in which the attorney practices. Then it goes on to say the limitations imposed by R 1:15 on attorneys shall not preclude assignments of partners, employers, employees, office associates, or shareholders by court for representation of indigents. Now, right here, what they're doing right here, it says attorneys shall not preclude assignments of partners, employers, employees, offices of associates, and shareholders. They're doing it anyway. Accepting assignments, meaning, suppose there are caseloads that might have came to me, a caseload that might have was handed to me, and I'm attorney or district attorney or whatever, and I can't take it. I can't accept that casehold, i.e. accept that assignment. I can't accept it. Assignments of partners. You might be my partner. You feel me? It might be a firm partner, firm business within a business in our professional business. Employers. It might be in the courts. Employees. Office associates. Shareholders. Some shareholders, it could be stockholders, which are nothing but freeholders. They're not supposed to be sharing assignments. Do you understand? They're not supposed to be even accepting assignments. Family, they're doing it anyway. As I said in the first part, that they're doing it anyway. Assignments of partners, they're accepting them. They're taking on cases, i.e. caseloads, and they're making tons of funds on the private side of these trust accounts. You see, they're doing favor for flavors. They're doing it. They're doing favors. They're doing favors for one another. Yes, they are. Then it goes on to say, B, I'm going to read this again. Municipal court judges, as applied to partners, employers, employees, office associates, shareholders, and members, the limitations imposed on practices of law by judges of municipal courts by R1:15-1B shall extend only to the county in which the court of the judge or acting judge is located, except for full-time municipal court judges and all judges appointed to the municipal court and city of Atlantic City. This rule shall not apply to the 2-year post-employment restrictions on casino industry related to activity referred to in New Jersey NJSA 52:13D-17.2C and imposed on municipal court judges by R1:15-1B. Well, the stuff that they're mentioning here anyway, they're all still doing it anyway. They're appointing magistrates even when they're retired. I'm pretty sure the family have heard of an appointed retired attorney. Do you feel me? Being heard, was appointed to hear your matter in your case. He's a retired attorney. But yet, it's making emphasis on particular attorneys shall extend only to the counties in which the court of the judge or acting judge is located. Listen, family, I've had judges removed from the benches. Do you hear me, family? Removed from the benches. And they end up sending that magistrate, right, to a whole totally different county in another whole different city, whole different jurisdiction. But yet this says right here that they're not actually supposed to be moved. Basically, it said, shall extend only to the county in which the courts of the judge or acting judge is located, except for the full-time municipal court judges and all judges appointed to the municipal court in the city of Atlantic City. Most of these judges don't, even if they were appointed to that particular county, they still send them to other counties to hear cases. They do. What they're doing is rotating all the bad apples and all the bad seeds. That's what they do. That's what they do. They do it all the time. The system is corrupt, family, period. But we're going to move forward with this. Let me read on. Municipal prosecutors as applied to partners, employers, office associates, shareholders, and members. The limitations imposed on the practices of law by municipal prosecutors by R1:15-3B shall extend only to matters that have occurred in the municipality in which the prosecutors serve, and any matters that involve law enforcement personnel and other material witnesses from that municipality. They don't follow this stuff. They don't follow this right here. They don't follow it because know why? Most people don't use these rules against them. They don't follow this stuff. Then it say right here, 1:15-5, application of rule, limitations under R1-15 upon the practice in criminal, quasi-criminal or penal matters, whether judicial or administrative in nature, shall extend to proceedings before courts and agencies or officers established under the laws of the United States. But in all other respect, R1:15 shall not apply to such courts and agencies. You see this? This is double speech. This is double talk. B, the terms office associates as used in R1:15 includes attorneys who share common office facilities. You see this? This is ambiguity, the stuff that they're saying in this stuff. The stuff that they're doing, and they're telling you the limitations on what they should not be doing. Family, they're doing it anyway. Because know why? Most of this stuff, they continue to get away with it because ain't nobody saying nothing about it, fam. The more the more we as a people don't say anything or voice anything about their violations, that they're breaking their own rules, we don't say anything, family, nothing's going to be done. Nothing's going to be said or done, family. But I'm going to move on to the more favorable thing that I wanted to talk about here today. Do you hear me, family? We're going to move on to, family, hold on. We're going to move on right here to piercing that corporate veil right there. Okay? We're going to move on to piercing that corporate veil, family. All right? Right here. Do you see that, family? Every city of every state, family, has a corporate veil, limited liability beyond piercing the corporate veil. So I could break this stuff down to you and explain to you what the police, family, because this is going to get beautiful here today in the second part. So that I can explain to you what the police and what all these public servants, these officials, these court officials, are doing to violate, their own rules, as well as the statutes, as well as the law itself. Okay, we're gonna read this right here, family. Okay, the limitations of the limits of limited liability beyond piercing the corporate veil. I'm gonna break this down to you because when I read it, I want you to understand what is being annotated. By conducting business as a corporation or a limited liability company, entrepreneurs and investors erect a metaphorical wall protecting their personal fortunes from liability from the torts and contracts of the enterprise. So, family, what they saying is people be using corporations like the corporate government, be using limited liability companies, right? So that it would actually protect the owners. Do you hear me, family? From claims, particular claims in regards to torts and contracts and things of that nature. That's why corporations are formed. Because what it does, it hides the owners. It protects them. This is the reason why we have trust. Do you feel me? This is the reason why we create trust. So that it can protect you in regards to particular contracts in nature. And or torts against one another or each individual corporation or whatever. So this is the reason why we create these or reason why they create, limited liabilities, in regards to corporations, so that it can try to protect the abnormalities that they do against people. However, when they violate your rights, family, that's what we talking about right now here today, part 2. Piercing the corporate veil. They can be stopped. It's just that we're not using the proper procedures to be able to do it. But free and happening here, I'm going to pinpoint our own abnormality and what we need to be doing and what to go after. Do you feel me? What we need to be doing and what we need to be going after in order to be able to focus in on, horn in on that particular thing that they're breaking the law. They're violating your rights and breaking the law. Do you feel me? When they're giving you tickets of that nature and these illegal child support and things of that nature and all types of stuff, stealing homes, all this stuff matters. All this stuff is actually applicable. If you overstand and listen to what I'm about to read to you, and you can pull your own piercing the code up. Like I said, don't just let free and have it just show you. You need to start reading and studying this stuff for yourself because, again, I don't see no one teaching this stuff. I'm hearing all other things, a lot of other things, but they're not going into the core interest on how to combat and start attacking the corporations to put a dent in their violations. Basically attacking the corporate veil. How to stop this corporation from, superseding their limitations on and their powers on their certificate of authorities, which is a certificate of incorporation. You see, because they've been granted and conveyed some type of power. Do you see? And under the assumption, they think that a person and a divine being, as I am, they think that they can violate that divine being status. And they think that a human and a corporation is one of the same. They deemed it one of the same and think that they can prosecute you under these corporate courts, with these corporate court firms. So let me get into this. I just wanted to explain that. Okay, it say, but okay, paragraph 2. Okay, no. Okay, this protection does not necessarily extend to the persons through whom the entities act, the directors, officers, and employees of the corporation, and the managers, managing members, and employees of the LLCs, all of whom are referred to hereinafter collectively as corporate agents. Do you hear me, fam? Did you hear that? This is the positions that they're playing when they're sending you corporate debt coming in the name of a fictitious entity. Do you understand? And we're participating in this fraudulent game. Directors, yes, they got directors of these companies. Officers, yes, they have officers. And employees of corporations. And managers, managing members, and employees of LLCs, all of whom are referred to hereinafter collectively as corporate agents. Do you hear that, family? Now, the concept of limited liability originally enabled large amounts of capital. Do you hear me, family? We're talking about funds here. Don't get it twisted. See, because this stuff going to start talking ambiguously, under a legal guise, and you may not understand it, but I'm going to break it down to you and give it to you in this raw form so that there's no secret words being spoken here. When it said amounts to capital, they're talking about funds to be aggregated by corporation from numerous individuals from major projects such as railroads and canals. Do you hear me, family? The individual investor whose relationship to the enterprise consists of only of making an investment and having the right to elect the corporation's director. Did you hear that, family? It said the individual investors whose relationship to the enterprise. Check it out. The individual investor whose relationship to the enterprise consists only of making an investment and having the right to elect the corporation's directors was able to limit his or her risk to what had been paid to purchase shares. So that's telling you, family, right then and there, within a nutshell, that his only interest is only making an investment and try to limit from anyone going into their pocket. Do you feel me? That's all that's saying. Basically, i.e. being sued. Once again, this is the reason why they create limited liabilities, i.e. corporations or corporate trust, so that it can protect them, the directors and everybody. As it stated up here, directors, officer, employees of corporations, managers and managing members, it's there to protect them. So they're trying to limit the risk right here, limit his or her risk to what had been paid to purchase shares. In regards to when charges are being hit against them, when they're putting out their investments on these shares, when they're purchasing shares, they want to try to limit any type of claims against them. All right. Members of LLCs, a form of doing business that developed in the United States about 30 years ago, enjoy virtually the same limited liabilities as shareholders in corporations. Now, let me move up. Being able to limit one's liability when going into a business encourages the creation of new enterprises, small as well as large, and the jobs, commerce, and benefits to the economy that follow. Today, many corporations and LLCs are in reality sole proprietorships or small partnerships made up of one or a few individuals. Did you hear that? Now we're going to read on because this stuff going to get good. By filing a certificate of incorporation. You hear that? A certificate of incorporation. That's like filing an article of incorporation. They're both are synonymous. They're like one of the same. It's similar to saying they've been granted a permission to operate under an article of incorporation. Like it speaks about the articles of the Bill of Rights, articles of the Constitution and things of that nature. There are incorporated things that rules that they supposed to be that's supposed to be granted under following they granted authority. There are rules that are governed under these certificate of incorporations or certificates, which they call. So this is the stuff that I pull out when I study that people don't know nothing about, which is again one of the same. It says by filing a certificate of incorporation or certificate of formation. Certificate of formation. Do you see that? So they're one of the same. They operate and activate, similar as one of the same, synonymously. They just make it redundant, whatever, which one you choose to, to go with. In the state capital, those individuals as shareholders or members obtain the benefit of limited liability to protect against the abuse of the privilege. The common law developed, check it out, the concept of piercing the corporate or LLC veil. Do you hear that? Thus, when owners fail to respect the rights, check it out, and duties of the separate personification, do you hear that, of their intimate creation, things that they created, they start basically breaking the rules. When it says when it say basically they fail to respect the rights and duties of the separate personifications of the inanimate creation. They respect the rules. So what they're doing is they're both sharing illegal acts together. That's what it's basically saying within a nutshell. They're basically sharing illegal acts together and failing to respect the rights and duties of one another. This one might break the rules against this one. He's breaking the rules against this one. That sounds like something that banks do. Am I correct? It sure is. That's exactly what banks do. Do you hear me, family? They have corporate veils as well. That sounds like things that banks do. Okay? Now, it says the courts may demolish the protective wall of limited liability and permit the agreed plaintiff to reach owner's response personal fortunes, which means when it says the courts may diminish the protective wall, which means they're saying that the courts have the authority to charge any personnel, any particular individual that don't follow the rules when it comes to limited liability rules and regulations. They have the right to charge you and bring you up on a charge and from the one who has been aggrieved, so that they can give him remedy. Do you hear me? Do you follow me? Where it says, once again, the court may demolish the protective wall of limited liability, which means you have no more protection, family. Once you break the law, once you no longer following the rules. Well, they been have not following the rules, family. See what it is, family? We're not following the rules because we're not studying this stuff. We need to do our own due diligence. See, because when you follow their rules, you learn their rules. It's like a game. Learn the game. It's all a game. It's like a game of basketball, football. Learn the game. Learn their position. If you could peep out their position, you'll win this game. So basically, this is what's going on. We don't even know their rules. Why? Because we don't study this stuff that I'm showing you here today. That's why free and habit is here. So it's a protective wall of limited liability and permit the aggrieved, the one who's been harmed, which is, aggrieved, who's the plaintiff, one who's filing on behalf of being injured, to reach the owner's personal fortunes, your wealth, your funds. I'm coming after you now. I want your money from you harming me. Do you follow me? This is giving a clear blueprint, family, how to breach that how to break straight through that corporate veil. Yes, there is a way. Do you hear me, fam? There is a way. See, people don't study this stuff. I'm creating so much powerful stuff as we speak, family. I'm creating so much powerful stuff to be able to help the people. Nobody doing what I'm doing. Nobody doing what I'm doing. You see, family? Things don't, listen, commerce, family, don't sit the same. The economy, family, it does not remain the same. Things change. The game changes, family. The game changes. The game changes, family. You got to know how to evolve and create different concepts, family. Free and habit don't stay the same. I change. I change my concepts, change my way of thinking by studying their game. Don't you know when you on playing a game of basketball, you got things change. Play game of football, the strategy changes, family. You got all the other gurus out there. You hear me, family? Using that same technique, that same stuff. Family, I'm always 20 steps ahead of the game. I'm always coming up with new concepts. This is how I'm able to beat them. Because know why? They constantly go in these secret rooms, having secret meetings, changing the game. Do you hear me, family? They're changing the game. So if they're going in these secret meetings, changing the rules, changing the game, how they're playing this game, you got to do the same thing. So that's just what free and habiting does. You see, they put their blueprint, family. They put their football, game strategy, family. They put it on blueprint, corporate veil. Yes, it is called piercing the corporate veil. This is their game plan. Okay, let's move on. It says the corporate agents' potential personal liability is distinct and separate from the liability of the shareholders or members. Do you hear that? Yes, they hide their capital, family. The corporate agents and potential personal liabilities is distinct. Do you hear that? It's distinct and separate from the liability of the shareholders or members. The piercing doctrine does not necessarily apply. Do you hear that? It does not necessarily apply to certain particular matters, but we're going to read in regards to what does matter, family. When they play this game on this court, they're playing it in a different form where it does matter. And I'm going to tell you that form here today. We're going to learn that here today. It says in Milgram versus Comfort Direct Incorporated, the court said, Listen up. Listen up, family. We right here. A judge is not required to pierce the corporate veil in order to enter judgment against a corporate officer. What that saying is, he's not supposed to, or he's not required. He's not bound under corporate law to convict. Do you hear me? To convict. See, I'm just going, seeping through the bull, all the legal language that they're just basically telling you that the judge can't actually charge a corporate member. Do you follow me? A corporate member, when some type of abnormality came up in regards to him violating you under some type of contract law or tort claim, depending on how the game is being played. But watch this. You see, it said a judge is not required to pierce the corporate veil in order to enter judgment, meaning to enter against that cop, against whomever that's doing the illegal acts against you, against a corporate officer, where, as here, that officer personally engages in unlawful activity under the Consumer Fraud Act. Now, family, worldwide, I know y'all listening to Free Habitat. Y'all got y'all got the Consumer Fraud Act. You got a federal Consumer Fraud Act, and you got local codes in regards to the statute under Consumer Fraud Act. Start looking that up. Start looking it up. And I guarantee you, family, it's going to pinpoint and start looking directly at you as the consumer. They're operating in commerce. Family, you are a consumer. You better believe it. They're looking at you as if you're a customer. Look this stuff up, family. Go Google the legal word consumer. And it's going to pinpoint to you, because they have this in black and white. Any family, you can look up United States Code Title 15, where it speaks about the consumer, where it's talking about if he's applicable to a debt, a particular debt. When someone sends you a bill saying you allegedly owe it, it says if the natural person owes it or if the corporation owes it, that they must basically verify who they're talking to, who they're allegedly speaking about, that is allegedly owes this particular form of debt or debts. Do you hear me? As a natural person or a corporation. But right now we're talking about corporations, family. You are being looked at as a consumer. Now, being that that's stated and said, we have in our child support, United States Child Support Manual, and we have it local, where we have codes. I'm not going to show that here today, but we do have it. I should have prepared it just so that I can show you. But I do have it. Maybe the next go around, I'll show you these codes where it lists you as a freaking customer. Do you hear me? Well, what's a customer? A consumer. They're under the assumption that they served you with something. Do you hear me? They served you with something, that you're a consumer. So consumer deals with something that's a customer and someone that's a seller. Is Free Habitat correct? Thank you. I'm sure I am. It deals with someone who's selling something and someone who's buying something. See, let's just skip through the bull. Someone is selling something. When you're dealing with child support, someone is selling something. Oh, yes. You're being looked at as a consumer. Yes, they list you as a customer under a code. They're saying you're a customer, family. And guess what? If you go into Walmart, right, and you choose to purchase something, right, family, you're a customer. Wouldn't you agree? You're going there to purchase something, buy something, and apparently Walmart must be the sales. They're the salesmen, men and men. They're selling something. They have something to offer, and you're the one that are accepting it, which makes you a customer. Do you hear me, family? This is commerce, family. Whether if you know this or knew this or not, this is commerce. So in the child support manual, local manual, it lists you as a customer. Family, what Free and Habit is bringing you right here, the Consumer Fraud Act, family. Under that act right there, family, they're violating millions of people's rights in commerce. How many people suing them under the Consumer Fraud Act? How many people suing these people under the Consumer Fraud Act? How many people violating the Consumer Fraud Act? How many people sending them documents in regards to the Consumer Fraud Act? Yes, if you get a ticket, family, that's under the Consumer Fraud Act, family. If you go in front of a judge for a ticket, family, I'm showing you proof that it deals with, you're being looked at as a consumer. I don't care what you say. This is commerce. So what Free and Habit is bringing you this information that they're using you as a customer. They're serving you something. Do you understand? Did you not get just served that ticket? Did you accept it? Family, y'all better wake up. You better wake up if you don't see what I'm bringing here today, trying to explain this to you. They're looking at you like you're a consumer. You're a customer. And they're violating your rights under the Consumer Fraud Act. Yes, they are. I'm going to read on. We're going to go through this. It says, consequently, even when shareholders or members have acted in accord with good corporate practice, have adequately capitalized the enterprise. Do you hear that? Adequately capitalized the enterprise? Has respected its separate existence, have not used it as a personal pocketbook. Watch this. Have dotted every I and crossed every T of statutory requirements and formalities. Check it out. In short, when there is no legal basis to pierce the corporate or LLC veil, the shield of limited liability may nevertheless be denied to the human agents through whom the corporation and the LLC acts. Did you read that, family? Do you read that, family? Let me go back. Let's read this again, family. Consequently, even when the shareholders or members have acted in accord with good corporate practice, have adequately capitalized, made a lot of money with the enterprise, have respected its separate existence, have not used it as a personal pocketbook, have dotted every I and crossed every T of statutory requirements and formalities. In short, when there is no legal basis to pierce or LLC veil, the shield of limited liability may nonetheless be denied to human agents through whom the corporation and the LLC acts. Now, it says the statutory liability, family, various federal and state statutes especially deny limited liabilities to particular corporate agents for particular acts or omissions made in connection with the enterprise. Perhaps the best known is Section 6672 of the United States Internal Revenue Code. Family, y'all need to start looking this stuff up, which imposes personal liability on the responsible. Now remember, it's going to speak ambiguous. It's going to speak ambiguous, but however, they're breaking the law still. They're still breaking the law because you got to catch this stuff. Perhaps the best known is Section 6672 of the United States Internal Revenue Code, which imposes personal liability on a responsible person who has willfully failed to pay over taxes withheld from an employee's wages. Similar provisions are found in the New Jersey Income Tax Act and the New Jersey Sales Tax Act. New Jersey's Consumer Fraud Act is applicable both to the enterprises. Did you read that, family? Did you hear that? I'm going to read it again if you didn't understand. It stated basically, family, that the New Jersey, and this ain't just New Jersey's territory, family. This is worldwide. This is all over. This is universal. Pull your codes. You got it? It says New Jersey Consumer Fraud Act is applicable both to the enterprises. Do you see? It's letting you know that it's applicable to both of them. There's no way around it. They're trying to say, oh, this don't apply. Yes, it does. I'm reading it right here. It says that it does. So when cops give you a ticket, they're saying that they're alleging that it doesn't exist. It doesn't apply. Yes, it does. Why? Because it's commerce. You being looked at as a customer. Yes. Consumer is a customer. So it does apply to you. It does, family. So it says right here, New Jersey Consumer Fraud Act is applicable both to the enterprise. And where liability is established, the corporate agent who personally participates in the violation of the statutes. So are they breaking the law? Are they violating their own statutes? Yes, they are. Even when they continue to give out tickets. Are they violating the Consumer Fraud Act with mortgages? Yes, they are. Are they violating this Consumer Fraud Act with child support? Yes, they are. They are. I don't care which one of them. You pick, choose, or refuse. It doesn't matter. They're both is applicable to the Consumer Fraud Act. Both of them. All of them. I don't care which one. Pick or choose. It doesn't matter. They're under this code right here. The Consumer Fraud Act. They all are. It's all commerce. It's all commerce, family. So it say courts have rigorously imposed personal liability in cases involve security laws. That's how I was able to bust what was that? Student loans. That's how I was able to bust student loans with security fraud. You see, I was able to bust them, and the Attorney General sued them on my behalf. You understand that? That's how I was able to bust them. You see? Because what they're doing is practicing security laws. It's fraud. All this stuff is fraud, man. Mortgages, that's securities fraud. Student loans, security fraud. It's all fraud, man. When you're talking about the backs of these trusts in regards to child support, that's security fraud too. It is. Whether if you know it or not, it's security fraud. They have a security interest in that that mortgage that they're under the assumption that Title 4D that this so-called loan, this so-called welfare funds that was given to maybe the mother, because it's sure more than likely it's not given to the father. He has nothing to do with no contract. He has nothing to do with that said contract, which is not even a contract. It's not verified. It's not backed up by no two-party signature. It's not. Definitely not from the ones who's acting as holders of the account, who's on your behalf for the women. It's all securities, family. So it says, such as when corporate officers intentionally inflate stock prices. Tell me you're not a stock. Tell me you're not a stock. You are. That's what that birth certificate is for. You see? You are on the stock market. You are stock. You chattel. You're a slave and don't even know it. It says misrepresent revenues and backdate stock options. Man, this is fraud. backdate stock options. They're doing it. They're doing it. Mortgages, child support, student loans, they're doing it. Car loans, they're doing it. They're backdating. They're backdate stock options. And it says other statutes imposing personal liabilities on corporate agents abound. Let me go up. Then it says, family, these statutes are not to be treated cavalry. The New Jersey Appellate Division upheld a default judgment taken under a Virginia statute imposing personal liability on officers of New Jersey corporations doing business. Tell me it's not business. Yes, I told you it's business. In Virginia, without a certificate of authority. Y'all need to start asking for their certificate of authorities. When someone sends you a bill, family, listen up. Listen to Free and Happy and Good. You got child support, someone sending you child support from a whole different territory, i.e. whole different state. Start demanding for their certificate of authority. Family. And the terms and conditions of that comes with it. Family, start asking for their certificate of authority. Family, I'm going to read it to you again if y'all not catching this corporate veil, piercing this corporate veil, family. It says the New Jersey Appellate Division upheld a default judgment taken under a Virginia statute. Do you hear that? It's not just Jersey. It just stated Virginia. Imposing personal liability on officers of New Jersey. Yes, corporation. Doing business. Yes. New Jersey also is a corporation. Don't think it ain't. Pennsylvania is also a corporation. Don't think it's not. Texas is also a corporation. Ohio is a corporation. New York is a corporation. California is a corporation. Arizona, South Carolina, North Carolina, Tennessee, Texas, all y'all. These are corporations that we're doing business with. Do you feel me? We're doing business with corporations. These are the things we need to simply start asking for, family. Take down notes. Take down notes. See, because I'm putting it together for you. I'm working this. I'm working this concept. Can't tell me I'm not on my due diligence, because I am. I stay on it. I stay studying. Don't think I don't, because I do. I stay studying, family. I stay studying. This stuff that I've been had. I stay studying. I just have to bring it out to you. It might seem old to me, but it's never old to you if you don't know anything about it. Okay? It's like an old record that no one has never heard. Then when I hear it, man, it's like sweet music to my ears. Well, this is the same thing. So take notes, family. Okay? It says intentional physical torts. A corporate agent enjoys no limited liability for his or her intentional physical torts. Yes, cop pull you out that, stop you in your car and you're traveling, or wherever you going. It's none of their business where you going. They have no probable cause to stop you, not unless they can verify causation, whom you cause harm to. Most of us are being targeted anyway. They pull you over just by looking like you know who you are. Just by looking like you know who you are. They just pull you over. They just pull you over. The way they're doing things now, they don't care about no color who you are now. It ain't about a color. Only one color they're concerned with. That's called capital green. That Federal Reserve. That's all they worried about. They don't care about no color these days no more. To some, but some then they go both. But for the basis of it all, it ain't even about color no more. Family. It's about the haves and the have-nots. Do he have knowledge? And do he not? That's all it's about now. It ain't about that color no more. to an extent. It's about the haves and the have-nots. Do he got some knowledge? Or do he not? So I'm going to move forward. A corporate agent enjoys no limited liability for his or her intentional physical torts. Thus, if a corporate agent assaults the obstreperous person on the other side of the bargaining table while attempting to negotiate a business transaction, he or she is personally responsible for the physical attack, notwithstanding the fact that the blow was struck during a heated discussion of price and terms. Family, don't think for a second they're talking about something that's physical. Family, they're talking about commerce. They're talking about commerce. Again, it says, thus, in a corporate agent's assaults, the obstreperous person on the other side of the bargaining table. When you speak about bargaining, who you're talking about, who you're associating with, it must be two or more parties trying to sit and scrutinize or get you under some assumption that you owe them. Do you hear me, family? They have a table, a fictitious, fraudulent table sitting up there, and y'all going back and forth. Well, that's the table that they're talking about. They're sending you something, letters, under the assumption you owe them something. Do you hear me, family? It says right here, while attempting to negotiate a business transaction. Do you hear that? So the language is telling you a business transaction. He or she is personally responsible for the physical attacks, notwithstanding the fact that the blow was struck during a heated discussion of a price. Price. Price deals with, once again, business. Where have I done business? How did I come into the personification of me having a contract with you where me and you talked over some particular fee, fare, fund, price? Where did me and you come to some comprehension where there's a price has been injected into this business where there's a terms set some of agreement is somewhere that I agreed to pay you? See, this is the corruption that they're doing, family. And Free Inhabitants trying to, discern and dissect the legal mumbo jumbo language that they're talking. Because all they're doing is hollering in legalese. I'm just trying to give you the thing. But it's also talking about how to pierce that corporate veil. So again, family, it says price and terms. Where a corporate agent sexually molests, now family, or harass another employee. Don't think, family, they're talking about physical. That's not what they're talking about, family. That's not what they're talking about. They're talking in a different connotation. Like if I sit and say, sir, when did you ever have intercourse or intercourse with me or interaction? People would think people who is ignorant to the law would think when I say intercourse, one who's ignorant to the law, they would be thinking that I'm talking about sex. No, I'm not talking about sex. I'm talking about some type of business interaction. When did I come to some comprehension with you and we sat down and had a business deal with one another? But people who are ignorant and who can't discern the legalese mumbo jumbo that they're talking when it comes to this legal law stuff right here, they can't dissect the information like I could, because I know how to do that. But these people speak in the legalese term, where it's talking about agent sexually molests or harasses another employee, although the entity may also be liable for the failure to take appropriate preventive action or failure to adopt an appropriate policy. The actor is responsible for his or her act. Family, They're talking about when you breach a particular contract in commerce, in regards to torts claims, in regards to contract world. That is a molestation right there. That is a harassment attack right there. So it speaks connotatively, you know. It could go either or way though, but they're more than likely they're talking about in a corporate term. So I want you to understand that because that's what it's talking about. We're talking about corporate terminology now. That's why it's piercing the corporate veil. We're speaking in corporate form now. So again, family, let's move on. It said intentional, non-physical torts. I don't know how long this video gonna be, family, but if I have to do you a part 3, I will. So bear in mind and hold tutorably with me and you know, until I can finish this because I gotta get through this. So if it gotta be a part 3, I will have to drop down a part 3, but I'm gonna give you this information. Do you hear me? Especially pursuant to the Consumer Fraud Act. We got to start writing these notes down. We got to start looking this stuff up. Okay. Intentional non-physical torts. A corporate agent who commits fraud will not be shielded because he or she utilizes the instrumentality of a corporation. It does not matter that the corporate agent was acting to benefit the corporations rather than to benefit himself or herself personally. The rule of law states in Hertz versus Philly, the officer of the corporation are personally liable to one whose money or property, did you hear that, family, has been misappropriated and converted by them to the uses of a corporation, family, in taxes. I'm pretty sure for those who's not ignorant to the law when it comes to IRC codes, Internal Revenue Codes. 6331, look it up. This is exactly what they do. They convert your status to theirs as a corporation. So when they send you out a notice, a lien, you sitting there be thinking that, oh, they just sent me out a lien. Well, a notice of lien is not a lien. It's only a notice. And guess what? They leave out the part A of the notice of lien and send you part C, D, B, C, and D, and E, and all the rest of them they usually send you. You see, they leave out part A where it speaks about the officer is the one that's applicable to the particular property in regards to taxes. It's just talking about the same thing. They steal and use your status and make you, what they do is they steal your property and make you draw upon his status, who is the corporation. So they're talking about the same thing. The officer of the corporation are personally liable to one whose money or property has been misappropriated or converted by them to the uses of the corporation. So this is what they're talking about. Although they derived no personal benefit therefrom and acted merely as an agent of the corporation. When sheriff coming to steal your house, your property, they don't act as an agent to the corporation. They do. They're no longer operating in their personal capacities as sheriffs anymore. All of them are corporations now. I got a couple friends who are sheriffs. They look it up for themselves and say, yes, we are a corporation. I thought we was under our own authority. And not under the authority of the judges. No, you're not under the authority of the judges. But however, you're contracted out with him. You see, they took that authority away from the sheriffs that you thought they had. They used to have it years ago. But now, family, they corporations. Every last one of them are contract and subcontracted out to this corporate government, to these courtrooms. Every last one of them. Yes. Are they still bound to the law? Of course. Don't get it twisted. Of course. Of course they are. Of course they are. They still must follow law. Period. but we need to start enforcing it against them. So, okay, let me move forward. Again, family, if this particular part goes out, I will be addressing a part 3. Okay? Okay, it says, although they derive no personal benefit therefrom and acted merely as agents of the corporation, the underlying reason for this rule is that an officer should not be permitted to escape the consequences of his individual wrongdoing by saying that he acted on behalf of a corporation which he was interested. Do you hear that, family? I'm telling you, this is teaching people how to hold them responsible for their actions, family. It is. Piercing the corporate veil is bad. I'm telling you, family, y'all better study this stuff. Nobody teaching this like Free and Happy. Ain't nobody teaching this. They're not teaching it. But I will tell you this much. I got a lot of trailblazers that's following along behind me. I don't hate on them, though. I don't hate on them. They follow right along behind me. I noticed that when I put something out, they're talking about the same thing. I don't hate you. I don't hate you. Love you. Love you. Because it's just letting me know that you're listening to me. So when you coming out with videos that's pertaining to the same thing I do, it's a beautiful thing. It's a beautiful thing. You're letting me know that you're following my trailblaze. I don't hate on you. It's a beautiful thing. Keep it coming, because I'm going to keep it coming. I'm going to keep it coming. We got to get this information. And I'm giving it like no other. I got to give it. I'm putting this trailblaze down. I'm doing it. And I got to keep doing it. Okay, family. This says right here, in short, intentional acts, whether a punch, a pinch, or prevarication can result in a corporate agent's personal liability. Did you hear that? I remember when we used to be in courts, when we were in courts or whatever, used to be in courts and the cop, I act as if he's about to lay his hand on me. And I turn around and say, sir, you better not touch me. Sir, listen here. No one's been arrested right now. No one has been arrested for no formal abnormality. If you touch me, I'm going to hold you liable. He was like, oh, no, I'm not touching you. I'm not touching you. I'm showing you right here, family, even if they pinch you, you can hold them liable. Don't believe me. I'm reading to you what the statute says. Under all this corporate veil, we're saying, in short, intentional acts, whether a punch, so much as a pinch, family, or prevarication can result in a corporate agent's personal liability. Do you hear me? So, family, don't come to me saying, oh, Free and Happy, they're telling me that I can't sue them. I can't do nothing to them. They're telling me I can't do. Don't you believe that? Don't you believe it? I'm showing you right now that you can pierce that corporate veil. I'm showing you that you can. It says right here. I don't care if they punch you. I don't care if they pinch you. I don't care if they pinch you. You can sue them. I don't care what they claim to do. You can hold them liable. Don't think no judge think that you can't pierce through that corporate veil. I just read you the case law above, where it says that he's not supposed to rule in favor of, in regards to the plaintiff. He's not really supposed to. But when you go after him, family, particularly pursuant to Consumer Fraud Act, family, they shall be held responsible. They shall be held responsible under negligence. And here it is right here. Here it is right here, family. Negligence. Direct involvement, action, whether it is the corporate president, driving a corporate car to a business meeting, or a corporate employee driving a corporation's truck to make a delivery. If either collides with another vehicle, the corporation may be responsible on the concept of respondent. General manager mistakenly pulled the brake rope, causing injury, and an employee, he was held personally liable. Family, they're talking about directly and indirectly. They're not just talking about a physical car crash. Remember, we're speaking in legal terms, talking about corporations, where it says employee driving a corporation's truck to make a delivery, or either collides with another vehicle. They're talking about personification and personification when if me and you're doing business with one another, you illegally collide with me outside of the law or the rules and your regulations, you will be held personally liable. Do you hear that, family? So now, omissions. Personal liability may follow from omissions as well as acts. Liability was imposed. When these jokers start lying, they will be held liable. Liability was imposed on a director for failing to prevent other directors from taking trust funds from the corporation. 15, international and complete failure of a board of directors to implement reporting requirements or controls, or intentional refusals to monitor an established system or to respond to warning signals, although a difficult case to make out, can result in a personal liability. A new director was held liable for breaching Indiana's security laws. Do you hear that? This is beautiful. A new director was held liable for breaching Indiana's security laws. Family, this is actually what they're doing. They're in breach of security laws. Birth certificate is bonded against a security. They have a secured interest in you. You are property. Don't tell me I'm not telling the truth, because they do. Child support, same thing. Student loans, same thing. They have a secure interest in you, in your property. Free and happy, what property you talking about? Your children, in regards to child support. Okay? So I say not because he affirmatively inflated stock prices or misrepresented revenues, but because he failed to make inquiries and receive no explicit assurance by management or counsel that the transaction he approved conform with applicable law. You see, they don't be following law. They don't never follow it. And guess what? They ain't never got to follow it. Because know why? Most of us don't study. We don't read this stuff. We don't learn none of this stuff. That's why Free and Happy in here to try to teach you this stuff. Certificate of authority,